Welcome to this presentation on Illinois wage theft and retaliation protections. As stated on the official website of the Illinois Department of Labor at labor.illinois.gov, the Illinois Wage Payment and Collection Act gives workers powerful rights. If you have been fired for complaining about unpaid wages, the law is on your side. Retaliation for wage complaints is illegal under both Illinois state law and federal law. This presentation will walk you through your rights, how to file a complaint, and what to do if you have been fired for speaking up. Let us begin. Illinois has a powerful state Department of Labor known as IDOL. Unlike many states, Illinois workers have a dedicated agency that investigates wage claims and enforces the Illinois Wage Payment and Collection Act, or IWPCA. The IDOL Wage Claim Unit accepts claims for unpaid wages, final paychecks, overtime, and vacation pay. You can file online at labor.illinois.gov, and it is completely free. No lawyer is needed. After you file, IDOL sends notice to your employer, who has 14 days to respond. An investigator reviews the evidence and issues a wage determination. Under Section 14 of the IWPCA, your employer can be penalized 5% per month on unpaid wages. The Illinois minimum wage is $14 per hour as of 2025, with overtime at 1.5 times your regular rate after 40 hours. IDOL enforces both minimum wage and overtime violations, making Illinois one of the strongest states for worker protection. Now, let us talk about the most important protection. Retaliation is illegal. Section 14C of the Illinois Wage Payment and Collection Act explicitly prohibits employers from firing, demoting, or discriminating against any employee who has made a complaint about wages. This is found in the Illinois Compiled Statutes, Chapter 820, Section 115, subsection 14C. What counts as protected activity? Filing a wage claim with IDOL, complaining to your supervisor about unpaid wages, discussing pay with coworkers, or even refusing to sign away your wage rights. Even informal complaints are protected. You do not need to use fancy legal language. If you tell your boss, quote, "I think you owe me money," end quote, that is a complaint, and firing you for it is illegal. What does retaliation look like? Being fired, demoted, having your hours cut, being assigned undesirable shifts, written up for minor things after you complained. If any of this has happened to you, you have legal remedies including reinstatement, back pay, and attorney fees. Beyond Illinois state law, the Federal Fair Labor Standards Act provides additional powerful protections. Section 15A3 of the FLSA, found in Title 29 of the United States Code, Section 215A3, makes it illegal to fire or discriminate against any employee who has filed a complaint under the FLSA. This covers complaints about minimum wage and overtime violations. A landmark Supreme Court case, Caston v. St. Gobain from 2011, held that oral complaints are protected. You do not need to put your complaint in writing. If you verbally tell your boss that you are not being paid properly and you are fired for it, that is illegal retaliation under federal law. If you prove retaliation, you can get reinstatement back pay with interest, and in some cases, liquidated damages, which means double your lost wages. The U.S. Department of Labor Wage and Hour Division can also pursue retaliation cases on your behalf for free by calling 1-8664-US-WAGE. Illinois workers have dual coverage under both state and federal law, giving you the strongest possible protection. The Illinois Whistleblower Act provides another layer of protection. Found in Chapter 740 of the Illinois Compiled Statutes, Section 174, this law protects employees who report violations of state or federal law to government agencies. Wage theft is a violation of law, so reporting it to IDOL or any government agency is protected activity. The Act also protects employees who refuse to participate in illegal activity. For example, if your employer asks you to falsify time records or misclassify employees to avoid paying overtime, and you refuse, the Whistleblower Act protects you. What can you recover under the Whistleblower Act? Reinstatement with full seniority, back pay with interest, compensation for emotional distress, and punitive damages in egregious cases. You also have up to 3 years to file a claim, which is longer than most other employment laws. But do not wait. Evidence gets harder to preserve over time, and witnesses may move away. Your case is only as strong as your evidence. Whether you file with IDOL, the WHD, or in court, documentation is everything. Start a daily time log today. Record your start time, end time, and any unpaid breaks every single day. Use a notebook or a free app like Clockify or Toggle. Save every pay stub, even the incorrect ones. Pay stubs prove what your employer actually paid you versus what you should have earned. Under the IWPCA, employers must provide wage statements showing hours worked, rate of pay, and deductions. If your employer is not providing proper stubs, that may itself be a violation. Save digital evidence like screenshots from scheduling apps, emails about pay rates, and text messages about overtime. Back everything up to personal cloud storage, not on your work computer. Identify coworkers who experienced similar wage theft. Witness statements can make or break your case. And if retaliation happens, document everything immediately. Date, time, who said what. A sudden drop in your performance ratings after complaining is a classic sign that courts recognize. If you have been fired for complaining about unpaid wages, here is your step-by-step action plan. Step 1. Preserve all evidence immediately. Copy your personnel file, pay stubs, time records, and any communications about your termination. Back everything up to personal storage. Under Illinois law, you have the right to inspect your personnel file. Step 2. File an IDWPCA retaliation complaint at labor.illinois.gov. This is free and no lawyer is needed. IDWPCA can investigate retaliation under the IWPCA at the same time as your wage claim. Step 3. File with the U.S. Department of Labor Wage and Hour Division by calling 1-8664 U.S. Wage. The WHD can pursue reinstatement and back pay on your behalf at no cost. Step 4. Consult with an Illinois employment attorney. Search the Illinois State Bar Association at isba.org for a referral. Many attorneys offer free initial consultations and work on contingency, meaning you pay nothing unless you win. Step 5. Consider filing a private lawsuit under the IWPCA, the Illinois Whistleblower Act, or the FLSA. You can recover reinstatement, back pay, emotional distress damages, and attorney fees. Do not let fear stop you. The law is on your side. If you decide to file a lawsuit for retaliation, here's what you can recover. First, economic damages. Back pay for all wages and benefits lost from the date of termination, and front pay for future losses if reinstatement is not possible. Second, non-economic damages. Compensation for emotional distress, including anxiety, stress, humiliation, and emotional pain caused by the retaliation. Illinois courts can award substantial amounts for emotional distress in employment cases. Third, punitive or liquidated damages. Under the FLSA, you can get double your unpaid wages. Under the Illinois Whistleblower Act, punitive damages may be available for egregious employer conduct. Fourth, and this is critical, attorney fees and costs are paid by the employer if you win. This means you can find a lawyer who will take your case on contingency. They get paid only if you win, and the employer pays their fees. Fifth, reinstatement. A court can order your employer to rehire you with the same seniority, benefits, and terms. This gives you significant leverage in settlement negotiations because most employers prefer to pay a settlement rather than take back someone they unlawfully fired. You do not have to navigate this alone. Illinois has a strong network of resources to help workers who faced wage theft and retaliation. The Illinois Department of Labor at labor.illinois.gov or call 312-793-2808 or 866-457-2205. They have offices in Chicago and Springfield. The U.S. Department of Labor Wage and Hour Division at 1-8664 U.S. Wage. Their Chicago office is at 1 North LaSalle Street, Suite 900. All services are free and confidential. Legal aid organizations. Chicago Kent College of Law Employment Law Clinic provides free services for low-income workers. Legal Aid Chicago at 312-341-1070. Prairie State Legal Services at 855-204-1302 for Northern Illinois outside Cook County and Land of Lincoln. Legal Aid at 877-342-7891 for Central and Southern Illinois. The Illinois Attorney General Workplace Rights Bureau at illinoisattorneygeneral.gov can bring enforcement actions against employers with patterns of wage theft. Remember, the law is on your side. Illinois has some of the strongest wage and retaliation protections in the United States. The IWPCA, the Illinois Whistleblower Act, and the FLSA all protect you. Document everything. File your complaint, and do not let fear stop you from claiming what is rightfully yours.